Viewers, welcome back to the show. Before the break, we're looking at a number of articles. The guys want to look at another article about a young fellow at Moomba, 1-year-old, fireworks, goes off, clay hits him in the stomach. Nuncio, what happened there?
Yeah, so, just an innocent, trip to Moomba with the family and, fireworks, and he's got hit by this wad of clay. And from the article, it doesn't seem like there's any long-term permanent damage, but it's still a fairly scary version of events. So.
Well, it could have been a lot worse, couldn't it, Alice? Could have hit him in the face.
Yes, that's right, Tony. You could sustain severe head injuries depending upon the size of the projectile and also who it hits, although he was only very little. And Moomba is an event that happens every year. It's a family event, and it is a bit dangerous, really, and it's a bit of a worry to know that it's a 1-year-old who's been hit by a wad of clay. As you say, the damage could have been a lot worse. So
I don't know what the answer is. I don't know if you ban those sorts of fireworks or not, but I guess it just means you've got to take more precautions.
You probably should also be looking at where the fireworks are being let off and whether or not they're giving enough leeway between the crowd and the fireworks as well, because I know generally speaking they let them off over water, but maybe they're not quite far enough away from the crowd in this instance.
Well, I've experienced the fireworks display overseas in Italy, and that was like being in a battlefield. There was actually projectiles flying all around the place. So I think we're a lot safer than what they are overseas, I'll tell you now.
Yeah, look, they're dangerous weapons, and I said, fortunately for this child, there's no long-term damage, but if there was, arguably you'd have a claim, Tony, don't you think?
For sure. But the child's only 1 year old, so effectively you've got until the age of 18 plus 3, to work out whether you've got a claim.
That's right.
Now let's get on with the topic of tonight, which is looking at policies of insurance, public liability, and who's covered by these policies. The first case we're going to look at is a case of CGU Insurance and Graham Robert Lawless. Alice, do you want to give us the facts?
Yes, Tony. This case took place on a farm and involved a fellow who was building fences with what's known as a post hole driver, which is quite a heavy piece of machinery that sits on 2 wheels. It's a little bit like a mini forklift, and it literally belts the post into the ground. And the fellow who was conducting the fence works had his young grandson with him on the day, and the little boy put his hand on the post in the way of the post hole driver and basically sustained a crush injury to his hand. And the case was mainly preoccupied with issues of whether or not the insurance company was going to cover the grandfather for the little boy, because the technicality...
That is to indemnify the grandfather for the insurance claim against him.
That's right. That's exactly right. The technicalities of the case required the grandson to sue the grandfather for damages as a result of the injury, and the case was really preoccupied with whether or not the policy was essentially going to kick in and cover the grandfather for not looking out for his grandson.
Do you recall the wording of the policy that was highly contentious in this case?
Yeah, the contentious part of the policy through CGU, I think it was that they wanted to exclude the grandfather from any insurance on the fact that he didn't take reasonable precautions, which is a term under the policy, and that was the big fight at the first instance in the Supreme Court and then the Court of Appeal as well.
Well, Nons, what the policy looked at was the wording was he had to take reasonable precautions. So the court had to determine whether the grandfather took reasonable precautions before the policy kicked in. And Alice, in the first instance, what happened there?
That's right, Tony. In the first instance, basically the insurance company tried to argue that the grandfather had been reckless and had not really been looking out for his little grandson. Because the wording of the policy was so central to this whole case, they were saying that he hadn't taken enough care for his grandson, and therefore the policy didn't have to kick in because there was no reasonable precaution. And so they found in first instance that, in fact, even though the argument was put forward by the insurance company, that in fact it was a grandfather with his grandson with him, and it wasn't one of those things where he'd be reckless about his own family. And so essentially they found against the insurance company and said that they had to cough up in this instance.
For the insurance company to succeed, the court wanted to know that the action was deliberate by the grandfather, and in this case they said it wasn't a deliberate action, hence why the reasonable precaution policy didn't stand up.
Well, on appeal, they found in favour of the grandfather, and it basically highlighted what was said in another case of Albion Insurance Company and Body Corporate Strata, where a failure to take reasonable precautions will only occur where there is a deliberate course of action or inaction that the insured realises exposes someone to the risk of being injured by recognised danger. So look, you're playing with words. At the end of the day, most cases people will be indemnified, don't you think?
That's true, Tony, and the court was really preoccupied with the fact that it was almost impossible to say that a grandfather wouldn't be looking out for his grandson, and even though on the appeal it was discussed at some length, it really is a words game at the end of the day, and it really is whether or not the insurance will kick in despite the facts of the situation.
What's interesting in this case is that the court didn't believe the grandfather that he wasn't aware that his son's hand, was in the way of this post. They didn't accept his evidence, and the insurance company tried to piggyback onto that by saying, well, the fact that he did know or should have known, then it potentially was a deliberate action, and they didn't take that next step, thankfully for the grandchild.
Yeah, but I mean, any which way you look at it, no grandfather would want their grandson's hand to be caught in
That's right.
a post-hole digger or driver.
That's right. No, that's right. And the insurance company tried to make out that the grandfather was being reckless because he was saying, well, I didn't know the kid's hand was there, but they were saying he should have known or did know. But at the end of the day, the court found that it was more of a common sense issue. I mean, what are you going to do at the end of the day with your family? You're going to look after them. So.
Well, I mean, you're really playing with words. Reckless, negligent. Bottom line, he was probably all of that.
Yes,
So
that's right.
this brings into question, and do you think people read their policies when they take out public liability insurance? Do they actually know what their policy states?
No. The majority of people wouldn't read their policies. People wouldn't even realise that with a home contents insurance policy, they're probably covered for actions that happen on the road or things that happen, in another state.
That's right. You can be off-site, as it were, not at home, that is, and you can be covered by your home and contents insurance, but it really does come down to the wording of your policy, and a lot of people don't realise what it is they're signing up to.
I had a case recently in which my client was injured while kite bugging on the 13th beach at down Torquay Way, and we wrote a letter to the defendant, and he didn't realise that his home and contents insurer would potentially insure him for that. Passed it on, and he's got insurance cover. So
It just highlights that if anyone's sued for a particular reason and you've got some sort of cover, you should really get someone to look at the policy carefully, because you think you're being insured personally, but you probably are covered under your policy. And the courts have shown a liking or tendency to support the person that's trying to rely on the policy.
Of course, yes.
Just on that note, let's go to this very interesting case of QB Insurance Limited and Win. It's a 2008 decision. Very interesting case. Nuncio, do you want to give us the facts?
Yeah, this was a case, Tony, which Mr. Newman was leaving a function and was attacked by a group of youths who they were also inside, and was stabbed and rendered paraplegic. And look, we'll go to the more facts of it and the implications.
Okay, well, we've got to
after
go to a break, so as soon as we get back from the break, we'll go to the facts and see what happened in court. Stay tuned, viewers.